Welcome to Infringe at Your Own Risk.
Hey there, welcome back to Infringe at Your Own Risk with Rand Bateman. Rand is a registered patent attorney with decades of experience protecting patents, trademarks, and copyrights for clients from startups to international companies. I'm Kevin Rosenquist, and today we're looking beyond US borders. If your invention, brand, or creative work could reach customers overseas, how do you keep it protected around the world? Rand is here to break down how international IP protection really works and what businesses should do before expanding abroad. Rand, welcome back.
Thank you, Kevin. Good to be back.
A lot of inventors and business owners might assume that a US patent or trademark covers them globally. Why is that not the case?
Okay, so patents and trademarks are very what we call territorial. So it's given by a given country and it affects the rights in that country. It does not generally affect rights in other countries. So it's very common that you can have, for example, with trademarks, people in different countries owning the exact same mark, even sometimes for the exact same goods. And I'll talk a little bit later about this, but this is one of the reasons why you should never let your distributors in a foreign country own your trademarks, because you can end up in a situation where they own your trademarks, not you, and then they can go substitute somebody else's product, use your trademark on it, and sell it in their country.
Oh.
So it's very important to protect your foreign intellectual property rights properly so you don't get in that situation.
Okay, so if someone wants to protect outside of the United States, what's the first step?
Okay, so the first step, I'm going to break these down because it differs by the form of intellectual property. So let's start with patents. With patents, you have to have a patent in a foreign country to stop someone else from making, using, or selling in that country. In order to get a patent in a foreign country, you have to file an application. And in most countries have what they call an absolute novelty rule. In the United States and a few other countries, you can market an invention for up to a year before you file your patent application. In most countries, however, the application has to be filed before you market. So it's very important, if you think you want international patent rights, to file a patent application in the US before you make any public disclosure about your invention. Then you have a 1-year window typically to file an application that will ultimately result in a patent in another country. And if you've done that, then you've protected those rights. But if you've gone out and started selling already in the US, you've probably lost the ability to get a patent in most foreign countries. So it's very important with patents that you not use it before you filed your patent application. With trademarks, in contrast, trademark rights spring primarily from use, especially in the United States. So you can be using a mark and developing rights in it even before you file your trademark application. However, many foreign countries have a registration process that gives rights, even if the people have never used the mark. So you can lose your trademark rights in a foreign country if somebody else sees your trademark in the US, likes it, they can run out and file a trademark in their country and get those rights, even though they've never used the mark in their country. And then effectively, if you want to go into that country with your trademark, you're going to have to buy the rights back from them or license them from them. So registering your trademarks is important. On the flip side, you can spend a lot of money chasing down every country. So you really want to target, okay, what countries are going to be important to me now, 5 years, 10 years, and figure out what the cost benefit is. You know, most U.S. companies are not going to be overly or negatively affected by somebody registering their trademark in Angola. Probably don't have a really big market there. It's not going to hurt you. But if you're a U.S. company that wants to expand, it is going to be a big deal if they get a registration for all of Europe and suddenly you can't use your trademark on your goods in the European Union or China or Japan. And so you can protect those foreign, but you just need to think, where am I likely to be and where do I want to prevent people from making my product?
Yeah, where's the market work for your invention, for your product? Yeah.
Right. And there's things even within markets like that. So for example, you can get a European patent. And then you pay money based on where you want it active. Well, you can spend an awful lot of money chasing down every country in Europe. And some are pretty expensive because of the translation costs. So many clients will just say, I'm going into Europe and I'm going to hit, it used to be part of the European patent, now a separate one, United Kingdom, Germany, France, Italy. That's like half the population of Europe in those 4 countries. So if you get the patent in those 4 countries, it gives you a competitive advantage in all of Europe, because it's harder for someone to make money competing with you if they can just sell in the small countries where they have to have, translations of everything. If you're selling into a country that's got 2 or 3 million people, it's a lot different than if you're selling in a country that has 80 million people. So it can have a big effect there, but it's important to think, what's my long-term strategy? Many companies just don't need it. I'm not selling to Europe. I don't plan on selling to Europe. You probably don't need a patent overseas. But if it's something you think you might be doing, it's important to keep those options open.
There's something called the Patent Cooperation Treaty, or the PCT. What exactly is that, and how does it simplify the foreign patent filing process?
Okay. PCT is a great tool for inventors. Originally, you filed your application in the US. Then you had 1 year per a bunch of treaties to file in foreign countries. And so if I wanted to go to China, let's say, I would file in the US. I had 1 year to file in China. It gets very expensive filing in all those other countries. The Patent Cooperation Treaty set up a provision that's handled by the World Intellectual Property Organization, in which you file an application, a PCT application, and the cost is typically $4,000 to $6,000 to do that. You then get an examination in the PCT stage, and they have an examiner comes, and the PCT examiners are usually very good and give you a good search and give you an idea of how patentable your invention is likely to be found in the member states of the PCT. After that, you get 18 months, then you go and nationalize. So it puts off nationalizing into other countries by 18 months, which can be a huge cost savings for a small company or a growing company. And then you get the idea of where it's going to be patentable. And then you can decide, okay, well, based on this, I only want to nationalize this patent into these 4 countries, or I want to do 40 countries. You can make that a better informed decision in the PCT application. Some countries, when they get a PCT search that finds patentability, you've basically got a patent. Their patent office will just rubber stamp it, push your application through, and you have a patent. Other countries are less deferential to the PCT search, and they'll go through and do their own. But still, you get a better idea of whether it's going to be patentable or not. The other good thing with the PCT is, because you get a search early in the US, things are slow right now. I've got a couple of cases that have been out more than 3 years and haven't gotten an examination in the US. If you have a PCT application that's been filed, early on, you'll get the examination, and it'll say, okay, we think claims 1 through 5 are patentable, but not 6 through 10. Okay, so I can now come back in what's called the patent prosecution highway to the US and say, claims 1 through 5 were found to be patentable in the PCT search. I want these expedited. And it puts it on a fast track. It gets examined, and often those claims will issue as a US patent much faster. And you can do the same thing in several foreign countries as well. So a PCT application is a very effective tool to save money and to get a faster resolution to the patenting process. There's some companies that will file directly into the PCT rather than filing the US case. They'll just file in PCT, get their search results and whatnot, and then based on what they get, times how fast they want to file in the US. If they've got a really good looking search report that says a lot of the claims are patentable, then they'll nationalize into the US from the PCT and use that to move in the patent prosecution highway and get a faster resolution of their patent application. So it's a very effective tool. And if you're looking at going foreign in more than just one or two countries, I would definitely use the PCT where it's available, because it's just a really good tool.
When it comes to trademarks, how does the Madrid Protocol work, and when is it worth using?
Okay, so the Madrid Protocol is kind of like the Patent Cooperation Treaty for trademarks. When I was practicing law early on in my career, I would get a trademark and my client would say, you know what, we're going to go into Europe. Okay, well then I've got to go file in individual countries, and then I could just file a European trademark application. But I would have to hire an attorney in Europe to handle that for me. So if I had a client come in and say, I want to file in Canada, Mexico, Europe, 3 countries in South America, and China and Japan. Okay, well then I've got to contact 8 different attorneys and have them file applications claiming priority back to the US application. With the Madrid Protocol, I file the application claiming to the US. It then goes through an analysis process by the World Intellectual Property Organization, and goes through a process, and they look at it and say, okay, does this look like it meets the pro forma requirements? Yes. Okay. Then it gets passed to the individual countries. The individual countries then look at it and say, is this acceptable? If the answer is yes, you get your registration is effective in that country. If the answer is no, you get an office action. At that point, you need to go hire the attorney in the foreign country. Well, I've saved myself $1,000, $2,000 per country by not having to have the other attorney involved in the very beginning. And for all the countries that the trademark office accepted my filing, I haven't had to use the attorneys there at all. It's dramatically reduced the spend of a lot of countries that do extensive foreign trademark work.
Yeah, I would say so.
And there's actually a sister to that for design patents now. PCT applications are for utility applications. For design applications, you can do what's called the Hague Convention, which is similar to the Madrid Protocol in that way. You're significantly reducing your spend on hiring foreign lawyers who, believe it or not, are often more expensive than U.S. lawyers. I frequently run into associates in law firms in countries that I would think attorneys would be a lot cheaper who bill more than I do. So,
well, maybe you need to raise your rates. No, I'm just kidding.
But yeah, I'm stunned sometimes. I'm like, not a third world country, but countries that definitely are not on the economic level with the United States. And you got these attorneys that are billing $700-800 an hour. And you're going, how do people in your country afford it? And the problem, probably a lot of people don't.
Well, I was going to say too, yeah, maybe they charge the Americans a little more.
Yeah. Yes, there's probably that. There's probably the gringo tax.
The gringo tax.
But yeah, so but it saves a lot of money being able to do a PCT or a Madrid Protocol or a Hague Convention. All 3 of those are just great tools. It streamlined the process. It saves time. It saves money. The World Intellectual Property Organization and the respective patent and trademark offices around the world are really commendable in that they're constantly looking for ways to work together to improve the process. And that's usually not what we think of when we think of governmental agencies. But they really do a good job of what can we do to speed up the process? How can we do patent searching that is more collaborative so we figure out if things are patentable or not quickly? How do we protect trademarks to reduce the cost to the trademark owner? Mm-hmm. It's just neat to watch because most of this is developed in during my career. And so I can remember how bad it used to be. One of the worst things when you have to go into some countries, not only do you have to send documents that are notarized. I mean, the US, you almost never need to notarize anything anymore. But in some countries, not only does it have to be notarized, you have to have an apostille, which means I have to get the document, I have to notarize it, I have to get confirmation of the notary from my state. Then I have to send it to the embassy of the country that it's the apostilles for. And then they give me a document and then I have to file it in that country. Mm-hmm. Okay. And it's like, okay, I spent more time getting this document certified than I did producing the document. And the Madrid Protocol and all of this has significantly reduced that type of time waste that used to happen on a pretty regular basis.
For a company that might want to sell online worldwide, what are one or two practical ways to prevent copycats or counterfeiters overseas?
Yeah, getting your intellectual property. It's the best thing you can do. If you have a trademark and you have counterfeiters, a lot of countries have significant penalties. In the US, there's significant penalties. In fact, counterfeiting is one of the few areas where infringing IP can actually be criminal. If you infringe a patent, that's usually not criminal, but if you're counterfeiting, that can be criminal. And in many other countries, violating intellectual property rights can be criminal. So it's important to have the rights, because if you go on, well, I have a US trademark, great. Well, somebody copies it in France, your US trademark doesn't do anything for you. Mm-hmm. And next, they have a registration on your trademark in France. Now you can't sell your own product without infringing their trademark. So, and there's provisions that for opposing trademarks, because there used to be quite the little industry where people would see a trademark in the US, they would run and register it in some country, and then they would demand that you pay them to turn over the registration.
Yeah, I'm not surprised. That seems like something people would do.
And some people are making pretty good money out of it.
I bet. Yeah.
But so now a lot of countries will have a provision where if you can show, hey, we have a US registration and it looks like the people were just copying to copy, you can go and get their trademark application rejected, by showing, I have this, they're copying off me and whatnot. So
if you can prove it. Mm-hmm.
Yep.
Interesting. All right. Well, that's it for today's episode of Infringe at Your Own Risk. If you're planning to take your brand or invention global, make sure your intellectual property protection goes with you. Visit batemanip.com to connect with Rand and his team. Don't forget to subscribe to our channel and leave us a review. We got lots more great content coming your way. Rand, it's always great hearing from you. Thanks so much for your time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.